One. Hello, everybody. This is Marc Cervantes, and we've got another episode of Cerv's Essential Service Provider. And today I have John Wiktor of Horwood, Marcus and Burke Chartered. He is a partner and an attorney there. He focuses on estate planning, and I figured today we would talk about that. We have a lot of clients that purchase properties and they don't have an estate plan. A lot of times what will happen is they will have a child, buy a new home, and realize that they don't have an estate plan. So that's why I'm having John speak today. So good afternoon, John. How are you?
Good, Mark. How are you today?
Not too bad. So, like I said in the intro, we have a lot of clients that don't have an estate plan. What would you tell people what an estate plan is consistent of? Because a lot of people think it's a very expensive and complicated process.
Thanks, Mark. It's not necessarily a complicated process, depending on what it is, but you should definitely have an estate plan. It's important. You want to be able to basically dictate where you want your property to go upon death, and that's what an estate plan does for you, rather than having statute or the Illinois government or Indiana government or whatever state you're part of dictate where your property goes. In addition, estate plan can be really important because not only does it tell where your property goes, but there's other things it can do. There could be tax planning within the estate plan. You can have planning for your kids or your children for asset protection. So it does much more than just where your property goes. There's a lot of planning that's involved, and it's important.
So let's say I'm a single male and I'm in my late 20s, early 30s. I'm not married, no kids. Would I be needing an estate plan?
Sure. Everybody does. As I said, without an estate plan, you're basically leaving it to the government or statute to say where your property goes. So as that single male, your property could go to your parents, your siblings, wherever the statute says. Wouldn't you rather dictate where your property goes? Wouldn't you also rather dictate the people who are going to administer your estate? Because within your estate, you name those fiduciaries who will administer your estate and help everything go along, not only where your property goes, but maybe have you buried or any other wishes you might have. You can put that all in an estate plan, and that's important.
So in the event that I don't have an estate plan or somebody doesn't have an estate plan, there's the concept of intestacy in several states. Could you explain what that is?
Yeah, intestacy is the statute that I've been talking about. Basically, if you don't have an estate plan, you look at the intestacy statute, and the statute will say where your property goes. A lot of times it may go down to your kids or up to your parents, sideways to your siblings. But again, you're looking at that statute to sort of follow along where everything goes.
So let's assume that a party wants to engage you. What kind of documents would you recommend for people? Could you go over the different types of estate plans?
Yeah, so our estate planning package, which we usually do for people, consists of a will, a revocable trust, and powers of attorney for healthcare, and a power of attorney for property. There's also some other ancillary documents, living will, and some other documents, but the main four documents are the will, revocable trust, and powers of attorney for property and healthcare.
Okay, can you explain why somebody would want a will versus a trust? Because I get that question a lot.
Sure. I would say probably most, if not all, of the estate plans I do right now involve a revocable trust. But what are the differences? So there's basically two differences between a will and a revocable trust. One, a will is a public document, a trust is private. So when you die, the will has to be filed with the probate court and everybody can see it. Versus a trust is private. Nobody can see the contents except for the beneficiaries. Some people care about that, some people don't, but that's one of the differences. Probably the bigger difference is anything that passes under the will has to go through the probate court. So you have to have a court process when you die. Whereas if you use a trust and you title the property in your trust during your lifetime, when you die, there's no probate process on that property. That's a big difference. You don't have to go through court. You don't have to pay for the court process. So that allows all the property to pass outside of the court. Now, there's some important needs for the will. The will, if you have minor children, you'd be appointing guardians in that document. You'd also be appointing an executor in that document. And that document will also say if you forgot to title something in your trust, basically put it into my trust when I die. But to do that, you still have to go through the probate process. So you need both, but the trust technically becomes the primary dispositive document.
So do you recommend, I have a lot of clients that already have living trusts, and when they get to my office, they're buying a new property. Do you recommend titling that property in the name of the living trust immediately?
They can. Yeah, generally speaking, most people will title property in their trust to avoid probate. There also is a concept for real estate called tenancy by the entirety. And Illinois statute, at least now, allows you to have property held in tenancy by the entirety between two revocable trusts if it's a husband and wife. So, generally speaking, when we're doing planning, we are having people title their real estate in some form in the name of their revocable trust.
So what things do people need to have prepared before they speak to you about moving forward with an estate plan?
Not a lot. My goal is to talk with the clients and discuss the situation with them and try to develop an estate plan that fits them, not something that's just spit out of a machine. Generally speaking, if they have a balance sheet with a list of their assets, that's important. Because one of the things that's forgotten is you do all these documents, but you need to do the titling at the end. You also need to get your beneficiary designations correct. So one thing we see a lot is people have a very nice estate plan, but for example, their retirement plans have no beneficiary designation associated with them. So we'll look at all the assets and say, this is the way everything should be titled, and these are the way the beneficiary designations should look. That's super important. In addition, you should start thinking about your fiduciaries. Who's going to take care of your estate? We also talked about the powers of attorney for healthcare and property. Those are very important. Those are two documents. The power of attorney for property allows somebody to make property decisions for you during your lifetime if you are incapacitated. And the power of attorney for healthcare allows somebody to make healthcare decisions for you during your lifetime if you're incapacitated.
So would that
So
be
you want to start thinking about the people
DNR?
who make those decisions.
Same thing as what that is a DNR then, do not resuscitate.
A little bit. I mean, the power of attorney for healthcare goes much further. It's not necessarily just do not resuscitate. It's I'm in a hospital and I'm incapacitated and I may not be dying, but I can't make the healthcare decisions for myself. So somebody may have to make the decisions on, do we do that treatment, this medicine, whatever it is. The DNR is much more limited on simply on that one specific instance.
When do you advise people, say they do an estate plan for you, then life changes. Maybe they do one when they only had one kid and they have a couple more kids. They gain property throughout their life. How often are we reviewing the estate plan just to make sure it fits the needs at that time?
Yeah, everybody should look at their estate plan at least every couple of years. The first thing you always want to do is look at your fiduciaries. Who have you named as your guardian of your minor children? Who have you named as your executor and successor trustee? Make sure, one, you still like those people and they're the appropriate people. Make sure they haven't died. That's a big change we see a lot. Two, laws change. For example, as of January 1st of this year, Illinois adopted a completely new trust code. And so that changed the way trusts are administered in Illinois. So if you're not looking at your estate every couple of years, and your lawyer should be updating you on this, but if you're not, you may miss updates to the law. So now many of my clients are coming back and updating their documents just so they fit within the new trust code. So as you look every couple of years, you're looking at your fiduciaries. Does your property go to the same right places? But the law is still the same as when you enacted your initial plan, because that can affect the planning.
Now, the laws that you're referring to are state-based laws, not federal laws, correct?
Those trust code one is state-based law. There is also federal law, for example, the estate tax law and the estate tax exemption. That's constantly changing depending on political parties or different things like that. But that changed with the new act that was enacted a couple of years ago. And then it could go down under this act. So there could be some federal law changes, but that's usually based on the tax laws.
So do you recommend, if somebody is moving from a different state to, say, Illinois, where we're at, to revise their estate plan if it was, say, drafted in California, for instance?
Yes. The estate plan will still be effective, or at least it should be effective. But every state has different laws. For example, Illinois has a state estate tax. A state like Florida has no estate tax. So that could change your documents. California is what's called a community property state. Illinois is called a separate property state. That can affect your estate plan. And every state, generally speaking, has their own powers of attorney for healthcare and property forms. So when you're moving to a new state, most states like to see their own forms. Even though your old ones should be effective, they like to see their new forms. So yes, if you're moving states, it's a good idea to at least talk to your attorney and discuss whether any updates are necessary.
Fantastic. Well, John, thank you so much for your time. If people want to contact you, how should they do that?
They can contact me by email, jwiktor@hmblaw.com, or they can call me. My direct line is 312 242-3305.
Well, thank you so much for your time. And if anybody wants to connect with John, he's done my parents, he's done my stuff. So definitely work with John. Thank you so much for your time.
Thanks, Mark. Have a good one. Be safe.